11 folks here. Look, let's try to get started here, because now today was the day that I was going to be starting to cover the due process of law. We had covered the Constitution in general in two different sessions, and focused on the A part of the articles and the B part of the amendments, and then had proceeded through the First Amendment, freedom of speech, and the constellation of rights around that, and then moved to, just push through the Second Amendment, which we, for various reasons of efficiency and time, I wasn't going to be focusing a lot of time on, and then moved to the Third and Fourth amendments. The Third Amendment prohibiting the billeting of troops in people's private homes, and the Fourth Amendment having to do with the whole issue of the right to privacy. Now, in that context, I had asked you to read this, the right to privacy. This is the big famous law review article at the Harvard Law Review that was done by Louis Brandeis when he was still a law student. He went on to become a justice of the United States Supreme Court, but this was a major article that he wrote when he was in law school that ended up being cited by the Supreme Court numerous times for the concept that around the narrow literal wording of the Fourth Amendment, there had arisen a penumbra that expanded out and around the Fourth Amendment to generate a general right of privacy, and that the same thing was done with regard to the First Amendment, that the freedom of speech had this penumbra around it that entailed freedom of expression, freedom of thought, freedom of belief, and that this concept, we'll talk about it when we get to the Ninth Amendment, dealing with the reality of there being unenumerated rights, that it isn't necessary for the founders to have specifically enumerated a particular fundamental right in order for people, we as the people, to have retained this right. And we'll talk a lot more about that when we direct our attention to the due process clause, both in the Fifth Amendment and the 14th Amendment. But we were going to be moving from the Fourth Amendment to the Fifth Amendment today, which contains the due process clause that states that no person shall be deprived of their liberty or their property without the due process of law. But what I want to do first, however, is I want to, in light of a certain development that happened today that you probably haven't heard about yet, that the Second Circuit Court of Appeals in New York City struck down the NSA surveillance system, the telephone surveillance system, the huge dragnet surveillance of all of your telephone conversations and all of your emails and all of your Google searches, etc., the thing that we've been talking about, and we're going to talk about a lot more in part 3 of the course, that much to everyone's surprise, the three-judge panel, by a peculiar vote of one opinion, the major opinion that was written by Judge Sack, one of the circuit judges, there was a concurrence on the part of a second of the three-judge panel, and then there was an apparent dissent. Well, I haven't gotten to the back end of this thing yet because we just got it. It's a 97-page opinion that came out this morning. But because of this, you're going to be hearing a fair amount about this in the next few days. And so what I wanted to do is I wanted to, given the fact that we had just gotten through talking about the Fourth Amendment on Tuesday, and we're going to be talking a lot more about it in the third part of the course, But I wanted today to address some attention to this, because as I say, you're going to be hearing a lot about this in the next few days. My guess is that it'll be one of the lead stories on all the news tonight, all the national news, and it's a big major front page story in the New York Times today. So I want to direct some attention to it, because the American Civil Liberties Union filed the lawsuit against the National Security Agency's surveillance operations, insisting that it not only did not comply with the statute of the Patriot Act, Section 215 of the Patriot Act, under the color of which this NSA surveillance system was being put into place, but more importantly argued that it was fundamentally unconstitutional, in that it violated the Fourth Amendment prohibitions on warrantless searches, in general searches. What the court did, or what the opinion did that was written by Judge Sachs, he said that, look, there's no need to get to the question of whether this is unconstitutional if both the Congress and the executive branch were to have joined together to authorize this. He said that but I'm going to look first at the arguments that are being made by the American Civil Liberties Union, that the scope and scale of the operation that the NSA has put into place was not authorized specifically by Congress, that this is a way too loose and overbroad a reading on the part of the executive branch of the authority that they've actually been given by Congress. Now, this is technically simply a statutory interpretation of the three-judge panel of the Court of Appeals, that they've said that basically we don't need to get to the question of challenging the constitutionality of the statute because as a simple matter of statutory construction, it's our position that the statute did not authorize what they're doing. And they went into some great length to detail why it is that the statute could not have authorized this. But shot through the entire opinion is this constant tone making it clear that Judge Sachs, anyway, felt that the statute was unconstitutional. But he didn't want to confront the question of its unconstitutionality, because there were some problems, arguably, about the standing of the ACLU to bring this case. And they'd had this really bad experience earlier with the Second Circuit Court of Appeals in the Hedges case, Chris Hedges case, with regard to the National Defense Authorization Act, authorizing the dragnet arrest and detention of people. The Second Circuit Court of Appeals reversed the district court, the regular trial court, on the grounds that he didn't believe that Dan Ellsberg and Chris Hedges and Naomi Wolf and the others really had standing, because they couldn't be absolutely certain that they were going to be arrested and taken into custody. And so there was a whole long discussion in this opinion today about the standing question. And so you could see that Judge Sachs was sensitive about that. And so he said, look, the standards for standing are different if they're just asking us to engage in a statutory construction. But if we're going to go to the length of declaring unconstitutional a statute passed by Congress and the conduct undertaken by the executive branch pursuant to the authority allegedly given to them by a statute, there may be a more stringent test for standing. And so therefore he avoided that entire problem. And he said, look, let's just focus on the statute and whether it gave them the authority to do this. And so what he did is he gave a very narrow reading, a very strict and narrow reading of the statute, of the Patriot Act, and kept on basically suggesting that Congress couldn't have really intended for this to imply that they had the authority to do this. Since they all agreed that it didn't specifically give them the authority to do this, the executive branch was arguing that by implication they were authorized to do this. But it's clear that Judge Sack undertook what is essentially a constitutional analysis of this, because he went into great lengths about the nature of the search that was being undertaken pursuant to the authority of the Patriot Act, Section 215. And he was saying that he started applying all of the same standards that one would apply to a Fourth Amendment evaluation of the statute. And he was pointing out that there's an extraordinarily important, there are two or three important aspects to this opinion that I want to share with you here today, because again, I want you to be considerably better informed about this than the rest of your fellow students who haven't had this course. You know, that they may be expecting you to know a little bit more about what's going on here. First thing you can say to them is, look, we haven't really taken up part 3 of the course yet, where we're going to be focusing on this and really digging into this. We've had general information about the Fourth Amendment, and so we have a kind of a speaking acquaintance with the Fourth Amendment now, but we aren't really familiar with it in some detail. So what I want to do today is I want to give you a little more than just a speaking acquaintance with the Fourth Amendment in the specific context of this NSA surveillance program that we're going to spend a lot of time on in part 3. The most important thing about this, and if you've been following it all, what Obama did, Obama issued a public statement about this. When Snowden, all of this has arisen because Snowden gave over all these thousands of pages to of his NSA surveillance stuff, of their internal documents, and he gave over the information about the NSA surveillance program. And he talked about how the surveillance program was implemented, the scale of the sweeping in all the phone calls and the process they were using. And there's a very kind of almost, well, entertaining at least, but it borders on being kind of humorous, the actual analysis that Judge Sack has here, because he points out that none of this would have been known by the plaintiffs if it hadn't been for Snowden. If Snowden hadn't revealed the workings of this particular program, it would have remained completely secret, and nobody would have been able to get standing to object to it, because the government would take a position that you have no idea what we're doing, and so you can't make an argument that you're being surveilled. And the executive branch would refuse to acknowledge you were being surveilled, and at the same time deny that you had standing, because they won't acknowledge you're being under surveillance. And so the judge basically points out that this argument has now been taken away from the executive branch, because Snowden has revealed what the details are, and he's explicitly revealed the fact that all of the telecommunications were being monitored. And so he said that obviously the plaintiffs are included in the all of us. And so therefore they clearly have standing. But that one of the things that Obama said, which was from a constitutional point of view, was patently, transparently ridiculous. Especially for a person who holds themselves out ostensibly to be a constitutional lawyer and litigator, as Obama has upon occasion. And that is that Obama said that, look, as long as all we're doing is gathering up all of the data from your telephone conversations, and we're not searching through it, we're not looking into the content of your conversations, and we're not exactly examining all the details of your calls that has been captured.
But they've just come out with the fact that they
No, don't do that. Don't do that, please.
Sorry.
Okay, but the bottom line is that he was arguing that they didn't need to get a warrant to search the content of your phone calls until they decided they were going to go in and look at the content. As long as they were just recording them and capturing them, there wasn't anything unconstitutional about that. And it's ridiculous. And Judge Sack went to the point of went to the length of saying, look, the point is that the Fourth Amendment prohibits the search and seizure of property that belongs to you. And he said so that it doesn't do the government any good to be able to argue that they aren't yet looking into your content of the phone calls, because they're seizing the content and keeping it around for when they feel like looking at it. And moreover, he pointed out that there was no judicial authority to whom they were going, even for the authority to go in and look into the content of what they had seized. That all they went to is the FISA court, the Federal Intelligence Surveillance Act court, and that the Federal Intelligence Surveillance Act court, out of 3,965 requests that have been made to them for the authority to look into the content of calls, in the last 35 years, only 12 of them have been denied. Out of 3,960 some of them. And so that he did not, however, go on to say that type of review was therefore virtually worthless. You know, he didn't confront the FISA court on this, but he just points out that there is no judicial review of it. But he did point out that the standard that is used by the FISA court to determine whether or not they can go in and look at the content of the call was simply whether or not they had a reasonable suspicion, it's quite interesting, a reasonably articulable suspicion that information might be discussed in the call that was relevant to the national security of the United States, or relevant to a potential terrorist organization, or relevant to the engaging in foreign intelligence activities by another nation. And so that the Fourth Amendment standard of reasonable grounds to believe that a crime had been committed, reasonable grounds to come to a conclusion that it was more probable than not that a crime had been committed, and specifically describing the particular article or thing to be searched out and seized as evidence of that crime, that we have come all the way from that place here to a place where all they think they need to assert to a non-judicial officer, but to a FISA court, that it's not an Article 3 court, is what they say. It wasn't a court created by Article 3 of the Constitution. That all they need to show is that they have a reasonably articulable suspicion that information relevant to an entire category will be discussed. That's got nothing to do with a crime at all. Okay, and not only that, he pointed out that under the regs that have been set up by the NSA, that the person who is going to make the determination that a reasonably articulable suspicion exists is in fact a member of the NSA that are going to be making that determination. So what he's pointing out here is that, look, what he's essentially saying is, look at, nobody in their right constitutional mind can conceive of this as being constitutional. And so therefore he suggests that he's going to give a very, very narrow reading to what it is Congress authorizes them to do, not because he's declaring it all to be unconstitutional, because he's suggesting that the Congress has to be assumed not to want to do something like that, because it would be so clearly unconstitutional. So it's a really interesting opinion in that sense, that he, on the face of it, is explicitly eschewing going into the question of the constitutionality of the statute and the unconstitutionality of the conduct itself. But he's applying a standard as to whether or not it would be constitutional as a mechanism by means of which he's going to determine whether Congress intended to give them that authority. So it's an extraordinarily interesting opinion. Now, because you're not familiar with how the procedures go, when a federal district court, which is a single judge, makes the decision, if you disagree with it, you appeal to the Court of Appeals, the Federal Court of Appeals. The Second Circuit Court of Appeals has 13 judges on it. And what they do is, as a matter of efficiency, they just have 3 judges look at the appeal. And the 3 judges, as long as 2 of them agree, they make the ruling. And usually they're speaking, in a sense, on behalf of all 13 judges. And they've, in a sense, been delegated the responsibility and authority to make the decision. And in 95 out of 100 of the cases, that just stands as the opinion of the circuit court. But there's a special procedure that is available, and that is that if there is not a unanimous 3-judge decision made, if there's a dissent, or if there's no agreement among the judges as to what the line of reasoning is, as to why they're making the ruling they're making, the losing party has a right to appeal to the full 13 judges. They call it an en banc. That's E-N, separate word B-A-N-C. It's en banc. That they're sitting en banc is as a totality of the Court of Appeals. Very rare that they come together to do a thing like that. We had it in our Pentagon Papers case, for example. But given the magnitude of this decision that's been made here today, just this morning, basically striking down the authority of the National Security Agency to continue to engage in this very controversial dragnet monitoring of all of our phone calls and emails and all of that, which you've noticed I've taken umbrage with any number of times already in the class, kind of caricaturizing what it is that they're doing. Because of the momentous nature of what it is that's happened here this morning, you can bet that the government is going to be appealing to the full en banc Circuit Court of Appeals. Now, the important thing to keep in mind is that all the courts, the Supreme Court and the other courts of appeals, by June 21st, they end their sessions. And so that you may not have noticed it, since many of you aren't pre-law people until we get done with this course anyway. That what happens is all of the huge opinions that the Supreme Court is looking at, they don't hand down the decisions until the last week of the session. You know, like from between June 15th and June 21st or so, that they put out these opinions if they're going to, declare gay marriage legal or illegal, or abortions legal or illegal, big things that are huge news items. They wait till the last week of the session. And so the question here is as to whether or not the federal government is going to seek an en banc review of this momentous decision and see if they can get them to do an accelerated schedule to actually rule an en-banc ruling on this before June 21st. So it's very timely that, you know, we're talking about all of this stuff, and the fact that we're going to be talking in detail about this this program that NSA has of the surveillance. I want you to read this case because I would bet that it's 75% likely that it's going to be appealed to the en-banc court. And my guess is it's probably better than a 51% probability that they're going to hand down an accelerated opinion on this. Now, a very peculiar aspect of this case, if you were in law school, you'd be kind of flabbergasted by this element of the decision. Judge Sack flatly asserts that the congressional statute upon which they're relying, the Patriot Act, even though he hasn't declared it unconstitutional, he's saying that this entire schematic that they've got, that they're operating on, is completely unlawful because it's completely unsupported by the statute. And yet, he did not authorize an injunction against their continuing to do it. In the case below, the plaintiffs, the ACLU, came to the district court asking for them to declare it to be beyond the power of the statute that was passed, beyond the authority of the statute, unconstitutional on its face, in asking for a preliminary injunction immediately, in asking for a permanent injunction to be imposed upon it being able to be implemented at all. And the lower court, Judge William Pauley, denied all of it to them. Said, you know, that he's taking the position that it's authorized by the Patriot Act in Section 215. It's not unconstitutional. He's not going to grant the preliminary injunction. And he went on to say that one of the reasons why he wouldn't grant the preliminary injunction is because it's obvious to him that they're going to lose on the merits. And he actually went so far as to say, I'm declaring that you're going to lose on the merits. So we don't even have to have a hearing. We don't have to take any more information or evidence. I'm telling you that I'm declaring it to be legal. And so he just wiped them out. And so it went on up to the 3-judge panel. And Judge Sack has said, look, I'm just looking at one of the things that he ruled on here, and that is his ruling that the Patriot Act authorizes them to do what it is they're doing. And he said it doesn't. And for that reason, I don't have to get to whether or not the statute is unconstitutional. Okay? And so what he's doing, to reiterate, he is making clear that he believes that if the statute authorized the executive branch to do what it is they're doing, that it would be unconstitutional on the part of Congress. And so he's saying that I'm insisting on reading the statute in a way that it doesn't authorize what you're doing. And so therefore I don't have to get to the question of whether it's unconstitutional. And but what he's doing, he's remanded the case back to the district court for proceedings consistent with his ruling, which means that he's going to give the ACLU, if they don't appeal it on up, he's going to give the ACLU the opportunity to get it declared unconstitutional. You see? And then the fireworks are really going to fly, because not only has he set himself up in contradistinction to the executive branch and what they're doing, but he set himself up in contradistinction to the Congress, in saying that the Congress, even if they wanted to do what you're doing, I'm not going to let them do it. So you've got a real full-scale confrontation between the judicial branch and both the Congress and the executive branch. Yes?
So then, are there advantages to not filing for an injunction against the specific actions of the NSA? I mean, I know the standing things make sense where he's trying to avoid certain issues and not trying to make certain, certain issues the central claims, but not filing for an injunction seems like
No, you should file for the injunction, because what you have to do is you have to conduct yourself in a consistent manner. And if you're maintaining it's completely unconstitutional, and you're seeking a declaratory judgment, declaring it to be unconstitutional, you have to ask them to enjoin it. You have to ask for a permanent injunction. And if in fact you want to be consistent with your arguments that the mere existence of this law is chilling everybody in the exercise of their First Amendment rights and is violating their Fourth Amendment rights, willy-nilly, you have to have the consistency of asking them to enjoin it. Now, in this particular case, it's one of the very few times I don't know as I've ever seen an instance, either at a district court level or a court of appeals level, where the judge has been so completely clear that it's unlawful what they're doing, but then turns around and supports the lack of an injunction against them. Now, it is true that the standards of review for an injunction are different than the standards of review of a statutory interpretation, but that's all very technical. So that we've got this really interesting situation right now that's directly in front of us in this class, in the things that we're doing, and more importantly, the things we're going to be doing in the immediate future, that you've got a hot one going on now, right in the federal court system. And my guess is that they go up to the en banc of the full Second Circuit. If the Second Circuit were to support Judge Sack in the three-judge panel, then the Obama administration Justice Department would go to the Supreme Court, because they're going to try to get it asserted. What they're going to do is they're going to try to get in behind the authority of Congress. And they're going to get in behind the authority and say, Congress clearly has the authority to authorize us to do this. That don't agree with Judge Sack, that they don't have the authority to do this, because he hasn't even really gotten to the constitutional question yet. Don't get hoodwinked by Judge Sack, because he's in effect ruling on the unconstitutionality of this. That's what's driving him into this kind of narrow construction of the statute. But that happens a lot. There's a lot of kind of strained efforts on the part of courts to avoid declaring a statute unconstitutional, and so they do this device of reading the statute very narrowly so as to save it from unconstitutionality. This is a classic device adopted by the middle marginalists. This is one of those devices that they develop, where they'll say, look, I don't want to get into agreeing with the natural law adherents of saying that this is clearly unconstitutional. I don't think we want to get to that. I don't want to criticize the Congress. I don't want to criticize the executive branch. What all they're going to say is that if you give a narrow enough reading to the statute, having adequate sensitivities for the Constitution, then you have to assume that they didn't intend to give this kind of authorization, because if they did, it would probably be unconstitutional. And so that's the situation that we have here. And I've got to get a chance to look at the concurrence, because I haven't seen what the concurrence says yet. But what it is that you are now engaged in real time with one of the key issues that we're going to be addressing in this course. And as I said before, Part 1 and Part 2 were all basically preliminary to get you on a speaking basis of familiarity with these constitutional concepts that we're going to be talking about in Part 3. But I'd hope to have Part 3 be basically half of the entire course, so that we can focus on how completely outrageous it is, what the W. Bush administration has been doing and what the Obama administration is continuing to do with regard to these areas. Okay? So And I want you to, in addition to reading the case, and I'm not going to, quiz you on the case. I'm not going to say, what do you think the differences are between the Judge Sachs' opinion and the concurrence, and and I'm not going to ask you a lot of those questions. I just want you to read this. It'll probably take you, with a moderately careful reading, it'll probably take you a couple hours to read through the whole thing. So I know that it's a significant assignment, but you're going to be happy to do it. You're going to be happy once you've read it to say, woo, wow, this is just exactly what we're talking about. Okay? And then you're going to see it on the national news in the evening. They're talking about it right currently. And you can just say to yourself, gee, this is exactly what we're studying right now. Okay? And you don't get to do that often at the university. So I want you to, in that context, I want you also, if you can, to do a read-through of Louis Brandeis's article in the Harvard Law Review way back in 1890, because he talks about the probability that there will be various technologies that will be developed scientifically in the future that are going to make it necessary for the courts to expand out beyond the most narrow possible historical reading of the Fourth Amendment. That we're not talking just about them coming into your house and looking at your documents and stuff. There are going to be future developments of technology that are going to generate additional areas of privacy that people need to be protected in, which is, I mean, it's downright prophetic what he's saying here. Okay, so these are, as I say, you don't want to go through a whole course that part of which deals with the Fourth Amendment and right to privacy, etc., and not have read Louis Brandeis's Harvard Law Review article. It's just a matter of being literate, in the field. So I wanted to point out both of these things to you here this afternoon to get them up onto your agenda, because we're going to be talking an awful lot about privacy and the Fourth Amendment and the security that you have in your person, of not being hassled by police and searched when you're walking down the street, or interrogated by police, etc. Okay, in part 3 of the course. So that's something I wanted to get up in front of us, and I'm not going to open onto that major set of issues today, even though it's tempting to do so, because I want you to have, this is just the kind of the arbitrariness of lawyers, of wanting to have things in kind of a careful, structured presentation, so it's easier to remember and easier to follow. So we've moved from the general discussion of the Constitution, Part A, Articles, Part B, Amendments, into dealing with the Bill of Rights itself. We've dealt with the First Amendment, freedom of speech, and the Constellation of Rights. We've dealt with the Third and Fourth Amendments of the general rights of privacy. Now we come to the Fifth Amendment. The Fifth Amendment is the one that when you first hear about Fifth Amendment, you hear of your Fifth Amendment rights, which is the right not to be compelled to incriminate yourself. That's the one that there's been a whole lot of hoopla around about why you got to get advised when you get arrested. That if you speak, the information can be used against you, and that you have a right not to answer any of the questions at all. And you have a right to an attorney, which is a Sixth Amendment right. But all of these are very major issues, and but they're very real, and you'd be surprised how completely insensitive, not just police. I mean, take that as a given. I mean, the police, the whole idea of you having a Fifth Amendment right not to have to answer all of their questions and do their investigation against you for them. I mean, they get downright indignant over the fact that you don't answer their questions. And not only that, but they take that as additional evidence of the fact that you did whatever it is that they suspect you of. you know? And so but I should tell you one of the cases that I worked on where this gets presented frontally. There was a guy by the name of Glenn W. Turner. Glenn W. Turner is the greatest living salesman that you'll ever hear about. Everybody knows he's the greatest salesman in the world. And he set all the records for the Hoover vacuum cleaner company, of a door-to-door salesman of vacuum cleaners. The thing that was particularly noteworthy about him is that he was born with a cleft palate and a hair lip and a club foot. And what he had done is he had developed an extraordinarily confident demeanor about him to overcome these things that he had been born with, and so that he had become this extraordinary person, and he went to work for the Hoover vacuum cleaner company and used to go to the door and always knock on the door, never ring the bell, knock on the door, and when the little woman of the house came to the door, he would put his club foot in the door like that. And so she couldn't get the door closed, and then he'd reach through and he'd throw dirt on her floor. And then he'd go, "Hi, my name is Glenn W. Turner. I'm come to sell you a vacuum cleaner," he'd say. And she would go, "What the fuck is this? You know, who is this person at my door?" You know, and so right away, she was kind of all off center. And so that what he'd do is he'd come in the house and he'd take out the vacuum cleaner and he'd clean up all the stuff, right? And she would go, "Wow, that's really something." And then he'd be in the door and he'd sell her the vacuum cleaner, the actual vacuum cleaner that he had with her dirt still in him. And so he had become this fabulous salesperson, breaking all the records of the Hoover vacuum cleaner company. And so what he did is he decided he was going to retire and he was going to set up a school. And he was going to train other people to become door-to-door salespeople, right? So he set up a school down right next to Disney World, down in Florida, called Dare to Be Great was the name of the school. And what he would do is he would, for $10,000, that's your full tuition for the school, that you would come down and you'd go to the school for 2 full weeks, and that it'd pay for your room and board at the school, all the classes, and then he would also give to you $10,000 wholesale value of whatever the product is that you wanted to sell. And it turns out that he owned 72 corporations, each one of which produced a different product, which he would make available to you. So you could sell Hoover vacuum cleaners, you could sell a Turnerware, which was these little plastic containers like Tupperware things. He would sell pots and pans, he would sell clothes, he would sell jewelry, he would sell cosmetics, and so whatever it is you wanted to sell door to door, he would for your $10,000 tuition, he would give you $10,000 worth of this product. So that if you went around door to door and sold all of the product that he gave you, you'd get your $10,000 back, right? But in addition to that, he would agree that he would give you the right to purchase any more amount of any one of the other products that he had at the wholesale discount rate. So you could then sell that too and be making a profit on the sale. And then the third thing that he did is he sold to you one of the franchises. That he had, each one of the states had 100 franchises in the state. And the unique thing that he had is that the franchise was not limited by jurisdiction, except to the state. So there were 100 salespeople could be in that state, but you weren't restricted to any kind of geographic portion of the state. And then the fourth and final thing that he sold to you was the right to sell the other 99 franchises. And that you would sell the franchise for $10,000, and you'd get to keep half of it. So that he was basically only getting $5,000 for each of the students that came to the school, was giving them $10,000 worth of wholesale equipment plus all of the training. And the people could, in fact, not only make all their money back just by simply selling that material, but they could also sell the franchises, the other 99, and get $5,000 for each one of them. And so that, in case you haven't recognized it yet, this was the actual origin of the pyramid sales for the Amway. And all that. This was the original pyramid sales system that he had. And what it was is that he was making so much money by doing this that he had people flocking into coming down there to his Dare to Be Great school, and was making tons of money. And all these people were running out around the country, you know, putting their foot in people's doors and wearing Turner wear or Turner clothes, you know, in these big gaudy American flags of these rhinestone American flags. And they were like Seventh-day Adventists, like coming to your door, you know, trying to sell you something. And it was making everybody crazy. And the fact is that the first place they went to try out their skills was Florida. Right, so they were branching out all around Disney World, out into Florida, you know, selling people everything, you know, and the people were going nuts, and so they started calling the police on them and calling everybody, and so that they finally, the district attorney in Pinellas County, which is right there where Disney World is, the assistant district attorney for Pinellas County came to his office in Coscott Interplanetary, which was his office. Coscott was the cosmetic line that they sold. And he had this big gigantic desk that weighed like about 3 tons. It was made out of complete pink marble, and a big gigantic sign in pure gold on his table that said, Glenn W. Turner, chairman of the board. And he used to wear these complete bright red suits with the white patent leather boots and the big rhinestone flags. So this is a very strange character that we're talking about here. And what happened is the assistant district attorney for Pinellas County shows up at his office and says, you know, that we're getting all kinds of complaints from people all around the state about what your people are doing, you know, and they want you prosecuted for this. But if you know, if you were willing to make a $25,000 contribution to the district attorney's campaign fund for the next election that's coming up, I'm sure that he would be able to push back against these demands. And so Glenn said, well, he says, I think I can do that. I can hear that, he said. So the guy gets up and the guy says, well, I want you to meet me with the cash, you know, in the Safeway parking lot, you know, on Saturday night, like at midnight. And so Glenn says, okay, we'll do that. So the guy gets up and leaves the office, at which point Glenn rolls out the drawer that's got the tape recorder in it. They had recorded the entire conversation. He calls the FBI. Right? He calls the FBI, and the FBI come over and they listen to it and they go, oh, you know, this is total corruption, blah, blah. You know, so they're going to set it up, and they're going to set up a thing where he's going to go to the parking lot of the Safeway on midnight on Saturday and have this guy and deliver the money to the guy, right? So 12 o'clock on Saturday night, Glenn W. Turner drives his great big gigantic bright red Eldorado Cadillac with the gigantic solid gold clacks and horns on the side of the bumpers, and he drives it into the parking lot at midnight, and he waits, and the assistant district attorney comes driving in his car, and he drives up near him, and Glenn gets out of his car and goes over to him, and the guy rolls his window down, and Glenn hands in a brown paper bag with $25,000 in cash, and hands it to him like this. And the FBI guys and the Justice Department guys are all hiding out behind cars in the parking lot all around there, right? So Glenn hands the guy the money like this, and the guy starts to drive away, and Glenn runs after him like that and throws himself in through the passenger window and grabs the guy and he says, "You're under arrest. I'm arresting, I was a citizen's arrest. I'm arresting you for illegal action. And he grabs him and tries to drag him out of the car. All the guys are going, oh no. The feds are all jumping out behind the cars. And they come out and they drag the guy out of the car and they arrest him and they bring him in. 2 days go by and they come back to Glenn and tell him they have to let the guy go because they can't figure out any federal law that he's violated. Because he wasn't doing anything to cross state lines. He hadn't gotten on interstate communications to try to extract a bribe or anything, and there was no federal jurisdiction. He said, you'll just have to go to the local district attorney. And so Glenn didn't think that was going to be very productive. But what happens is the following Monday comes, and he finds out that he's been charged by the local district attorney with a fraud, a constructive sale of stocks without being a registered salesperson of stock certificates. Because he was, in effect, pursuant to their interpretation, he was giving people too large a percentage of the profits of the company. That he was giving them away in exchange for their $10,000. He was giving them an ongoing share of the profits of the company, they said. And so they had this whole thing figured out that it was a constructive sale of a stock without him being a registered salesman of stock certificates. And so they arraigned him at the local court in Pinellas County. So he shows up there that Friday for the arraignment. And he comes to this little town where it was there in Pinellas County. And it turns out there are like 3,000 Turnerites, as they called them. All had shown up in their bright red clothes and their big wigs, all powdered wigs that the women had. And that they start demonstrating, marching down the street by the courthouse. And so Glenn is walking down in front of them like the hero, and they've got big signs and supporting him and stuff. And so I guess this is what a demonstration looks like. And so they march down the street, and he comes into the courthouse, and they get there for the arraignment. And the local district attorney says, Your Honor, before we proceed with the arraignment on these charges of fraud and engaging in a sale of stock without being a registered salesman of stock certificates, I want to have an emergency hearing convened for contempt of court, that whoever it is that was behind organizing this demonstration around the courthouse, there's a statute that makes it illegal, a crime, to demonstrate within 500 feet of a courthouse. And so I want to have a preliminary hearing on contempt of court, and the first witness I want to call is Glenn W. Turner. And he serves Glenn W. Turner with a subpoena to have to appear in front of him. So Turner is kind of freaked out, and he says, and the reason that this becomes salient for me is because they're getting set to put him on the stand and order him to answer questions under oath, the sole purpose of which is to try to get him to incriminate himself of this crime that they've already asserted. And so it turns out that a month prior to this, when he realized that they were investigating him earlier, he had asked somebody who the best criminal defense attorney is in the entire world, and he had been told it was F. Lee Bailey up in Boston. And so F. Lee Bailey had been hired by him to be his lawyer. Another colorful story. But anyway, he'd been hired to be his lawyer. And so Lee Bailey called me up out of the office, that I was in Bailey's office at the time, and flew me down there to have to deal with this thing because they put Glenn up on the stand, and the district attorney got up and swore him under oath and said, okay, now there's this criminal demonstration going on out in front of the courthouse. What did you have to do with this? And Glenn says to him, I don't have to answer your questions. And the BJ driver, who was the judge of the court, says, excuse me, he said, are you refusing to answer that question? And he said, yeah. He says, I have a Fifth Amendment right not to have to answer questions like that. And the judge said, well, I take it from your refusal to answer the question that you're guilty. And I hereby convict you of criminal contempt of court and sentenced him to 6 months in jail, just like that. And then they dragged him off the stand and put him in jail. So this issue of the Fifth Amendment right that you hear about, I'm pleading the Fifth. I'm pleading the Fifth. I'm pleading my Fifth Amendment right not to have to answer that question because it's intended to solicit information which will be used to incriminate me. Now, there's a big, long history to this whole Fifth Amendment thing. This is what I happen to have written my thesis on at Harvard College, my honors thesis from the undergraduate school. So there's a big, long, and deep history of this thing because this is what they used to do all the time. The king's men used to go out and drag people in, and they would put them under the oath. If they wouldn't take the oath, then they would put them in jail for contempt of court. And if they did take the oath and they asked them questions and they lied, they would put them in jail for contempt of court. And if they answered the question and provided any information of any kind that indicated they had done any kind of offense at all, they would put them in jail for it. And so this procedure that had been developed in England and other places in Europe was anathema to the colonists. And so that they put right straight into the Constitution this right not to be compelled to provide evidence against yourself in a criminal case. And so this is one of the very well-known portions of the Fifth Amendment that's in the Constitution. And it's one that, instantaneously you would recognize. But the other one that's in the Fifth Amendment states that no person shall be deprived of their life, liberty, or property without the due process of law. And so right away, you've got right on the face of the Fifth Amendment to the United States Constitution, right in 1791, this whole assertion that there is somehow an understanding that there is a due process of law that has to be respected before you can deprive any person of their life, liberty, or property. Now, to start out a discussion of this, it's pretty clear what one might be talking about if you're talking about depriving someone of their life without the due process of law. It's not so easy when you say, well, the person would be deprived of their liberty without the due process of law. Obviously, if somebody was going to be arrested and put in jail and held in jail for some period of time, they're being deprived of their liberty. That's clear that that's part of it. But what about other liberties? What about other types of liberties that a person might have? What about the property? When you're saying they can't be deprived of their property. Okay, if they wanted to come and take your house away, that's pretty obvious. Or take land that you had, or take your horse, or take your buggy, or take your whatever it is they wanted to. That's clear. But what started to develop over the years was a question of what type of property interests might you have that weren't just like a piece of real estate or a piece of tangible property. What other kind of rights did you have? For example, if in fact you were say you were a government employee, and let's focus first on the federal government, because the Fifth Amendment, remember, addresses only the federal government at the start until we get all the way to the 14th Amendment and get to the Civil War. So all the way from 1791, all the way up until 1868, these rights that are set forth in the Bill of Rights are assumed to apply just to the federal government. And so you've got this question that arises is if a person were a federal employee and all of a sudden the head of the department, say you were hired and you were in the State Department for the United States at that time, and all of a sudden the head of the State Department comes in and says, you're fired. That you've been here for 5 years, 6 years, and you got a family and kids and everything else, but you're fired. And you go, well, what for? And they say, I don't have to tell you what for. And you don't have any right to appeal to anybody, you're done for and you're out. The question is did the person have any kind of a property interest in their job? for example. And so but there were comparatively few. There were comparatively few cases that came up during that entire time, from 1791 all the way to 1868. There were comparatively few cases came up under this particular statute because there weren't that many federal crimes for a person to be provided due process if they were going to be deprived of their liberty. And there weren't that many interests, property interests, that the federal government was in the process of taking away, except for all the Indian property. But they weren't citizens, and so they didn't think they had any rights under this. And so that this issue of providing people the rights of the due process of law before they could take away their life or liberty or property didn't get fleshed out very thoroughly in that first period of time over and against the federal government. But what they did do, however, is there were a whole series of procedures that they started to develop in those rare cases that they had with regard to the federal government. If you were going to be charged with a crime by the federal government, even though they were quite rare, they began to be very clear about a series of natural rights that people had to be given a fair hearing. For example, it became very clear that if you were going to be arrested by a federal officer, that you had a right to know, first of all, what are you being arrested for? You know, what are you being charged with? Okay? And secondly, you would automatically say, you know, okay, if you tell me what I'm being charged with, why am I being charged with this? What information is it that you have that causes you to believe that I've committed this offense that you're charging me with? And then thirdly, and very famously, it says right in the Constitution itself, is that the writ of habeas corpus shall not be denied. And so the writ of habeas corpus is, even though it's technical Latin stuff, what it means is that if you're arrested by a government authority, you have the right to go in front of an impartial judicial magistrate. And the judicial magistrate then will require the arresting authority of the executive branch to provide evidence, as it says in the Fourth Amendment. It'll provide evidence to show that there's evidence that a reasonable person, if they saw that evidence, would conclude that it's more probable than not that you committed the crime that you're being charged with. And so therefore, there's a rational reason for making sure that you're going to be available to come to trial. And so that you've got a right. And then there's an additional one, and that is that everybody who is charged with an offense is entitled to reasonable bail. And that is that if they say, look, you've been charged with stealing your neighbor's horse, and you're going to go to trial in 2 months from now on that, you have a right to say, look, what agreements do I have to make that are making it reasonable that I'm going to be there at the trial, that are other than you just putting me in jail and holding me there as if I were guilty already. And so that it says in the Constitution that a person shall not be denied reasonable bail. So that's another piece of the due process, okay, in the criminal process, okay. And so once you've gotten the reasonable bail, then you come to the hearing itself. And one of the prerequisites of the due process of law in a federal criminal procedure was clearly that if you come you have a right to have a hearing. They can't just say, oh, we're going to present the information to a judge, and the judge is going to decide whether or not you're guilty or not, and you don't get to participate in it. You know, they knew right away that was not fair, because it says in the Constitution itself that any person who's charged with an offense has a right to a trial by jury, a jury of your peers. That's another one of the aspects of the due process. And so that clearly makes it clear that you're going to have a hearing, a hearing with a jury there. And you have a right to have also an impartial judicial official presiding at the trial, so that the judge will make rulings on how the hearing is to be conducted that you're entitled to. And so an additional factor is that you have a right to have that be a public trial, that you can't be tried in secret. And now all of these things have long historical roots, that only because those rights were not given to people in the past. For example, you'd be tried in secret, and the king's people would come in and they would accuse you of the stuff, and they would right away just say, "We've accused you of this. You have to prove that you're innocent." So that's another one of the aspects of the rights under due process of law under the Constitution, is that you have no obligation when charged with an offense like that. You have no obligation to prove you're innocent. The burden of proof has to be on the state. Now that may sound fairly elementary, but the fact is it's a prerequisite of the due process of law, because there was a point in time historically when that wasn't so, that you basically had to prove you were innocent if the king's men charged you with some kind of an offense. And so that this presumption of innocence is a major factor in the due process of law. You have to be accorded the presumption of innocence. And because of the Fifth Amendment right not to be compelled to provide evidence against yourself, you have a right to be silent. You don't have to answer any of their questions. Okay? And moreover, an additional element of this due process of law would be that the prosecutor doesn't have any right to argue to the jury that your refusal to take an oath and get on the stand and be interrogated by the prosecutor, that cannot be weighed in any way as suggesting that you're guilty. And that they need to understand that, because this Fifth Amendment right not to be compelled to present evidence against yourself, there's no other reason why the prosecutor would want you on the stand other than to get you to incriminate yourself. And so that an obvious corollary is that the prosecutor has no right to argue to the jury that your silence can be taken as evidence against you. Okay? And then, of course, there's the obvious one of the right to a jury. Okay? A right to a jury trial. And the question then came up a number of times about, well, the historical jury was a jury of 12 people, of your peers. And so was it necessary to have 12 jurors? Could you have less jurors? What about 6 jurors? And so that came up, and there was a whole bunch of discussion about it. But the fact is, there wasn't any doubt about your being entitled to a jury. And it also says a jury of your peers. So that's another element. It's a subcomponent of the right to a fair jury trial, that the people on the jury have to be a jury of your peers. So that means that if you're a regular person, you can't have a whole jury of aristocrats sitting there passing judgment on you that are from an entirely different class of people. And in that sense, if you're, we've never seen those cases, but if you were an aristocrat, that you can't have a whole bunch of peasants deciding to sit on the jury against you, because they may harbor a class prejudice against you. It may be merited in that case, but the bottom line is, so that another one of the aspects of the due process of law is that you have a right to a trial by jury and a jury of your peers. Okay, and then the other obvious one started to be is that, and we touched upon a little bit earlier, is that you have a right in the trial to be notified of not only the nature of the charge against you, but the details of the evidence that is the basis for charging you. so you know how to defend yourself against it. And whoever it is that's accusing you, here's another major one, whoever it is that is accusing you of the crime, because in 95% of the cases, it's not going to be whoever the state officer was that arrested you. Someone else is the one that is making the accusation against you that you did this thing. You stole my horse and I saw you do it, and so I'm the witness against you. Or, you know, you burnt down my house and here are the witnesses that saw you do it. Or here's the evidence that we gathered to make us believe you did it. So one of the other aspects of the due process of law is that you have a right during your hearing to confront the witnesses and your accusers. So any person who's going to be accusing you of having done this offense, you have a right to examine them in the course of the hearing. And you have a right to do it through an attorney. That's another aspect of this. Now, it took a long time to determine that, you know, if you didn't have the money to hire an attorney, you know, it was not way until 1961 or so in Gideon v. Wainwright that they decided that if you didn't have enough money to hire an attorney, that it was an absolute prerequisite of a fair criminal trial that you had to be represented by counsel, and therefore the state had the obligation of providing counsel to you. But that didn't exist for 100 years, you know, from 1868 even. And it didn't exist for another 100 years prior to that. But the bottom line is, if you had an attorney, you had the right to have your attorney there, and your attorney could examine your accuser face to face. Now, this is something that everybody isn't instantaneously aware of. We've had instances where I've had to sit and go through details with people. If they're getting set to have some kind of a tribunal, they had to have an understanding that whoever it was that was making the accusation had to appear in person. It had to be available to be challenged and examined on this thing. Okay, so you've got the right to confront your accuser, and you have to have the right to call witnesses on your own behalf and make them available. They have to be given the right to testify to the jury if they have information that is indicative of the fact that you're not guilty of this offense. Okay, and the fact is, an additional aspect of this is that you have to have, in addition to that, the right to get access to subpoena power. You have to have the right to have the court issue subpoenas to make people come in as witnesses if they're reluctant to do so, even if they saw the whole crime and they saw exactly who did it and they know that it wasn't you. There are instances where the people still will not want to come in and testify. They don't want to get in trouble. They don't want to become involved. They don't want to be retaliated against by the relatives of the person that they know did it. You know, there's all kinds of reasons why people who are clear witnesses who can exonerate you might not want to come. And so you have to also have the right to have access to the compulsory subpoena power to compel witnesses to come in and testify. Okay? And you have the right, because of the nature of the history of the jury trial, you have the right not to be convicted unless the jury is unanimous. And an additional factor, we should have probably been numbering these so you remember how many there were, but one of them is that you have to be convicted by a unanimous verdict. Okay? And because of that, another aspect of the right to the jury, it has to be a fair and impartial jury. So you have to be given the right to what they call voir dire. You need to have the right to interview the prospective jurors to make sure that they're fair and impartial. So there's another aspect to the due process hearing in a criminal context here, is you have to have the right to take procedural steps to assure yourself that the jury is fair. I should give you an example of this. When we were representing the first elected black mayor in the deep delta of Mississippi. Actually came from a little town called Chula, Mississippi in Holmes County, way down in the deep delta, 50 miles south of where Schwerner was found. The civil rights workers were found buried in the mound there that was in Mississippi Burning, the movie and stuff. So we're 50 miles south of that into the deep delta. And the first elected mayor, a black mayor since the Civil War, was charged with first-degree murder. And we've been brought in to defend him. And so we're getting set to pick the jury, and we're in this courtroom. I mean, it was right out of like To Kill a Mockingbird. You know, I mean, this little court, and no black people were allowed to sit on the first floor. This is 1984. No black people were allowed to sit on the first floor. They had to sit up in the balcony, up there, and all the white people sat down on the first floor. And they had these fans going. There were these like little motors, little kind of a motor on the wall that kind of spun around like this, and it was hooked onto a rope. And they came up, and there were these fans that were going like this. You know, they had these big wicker, made out of wicker fans going like this in the courtroom. You know, of course, all white judge, all white prosecutors and stuff. And what had happened is this mayor was being accused of first-degree murder because he had gotten to go away to college and went to Ole Miss Law School. It completed 2 years of law school. His father died, and he came back home and was running the all-black country store. This place in Chula, they had a railroad track that went right straight through the middle of town, and one whole side of the railroad tracks was all black, and the other whole side was completely white. And in 1984, and they had a Christian academy where all the white kids went, and the black kids were in an all-black school. And he had come back from law school, and he organized a big voter registration drive, because 86% of the population in Holmes County, which is the 10th poorest county in the entire United States, of the 3,030 counties in the entire United States, you take the 10 poorest counties in the entire United States, this was the 10th from the bottom, right? 7 of the remaining 10 are on the reservations in the state of South Dakota. 7 of the poorest 11 in the country, okay? But this was the 10th poorest county, Holmes County, and 86% of the population was black, but had never voted. And so when he came back, he and Arnett Lewis, a friend of his from Ole Miss, helped organize the people to vote. And so they all got organized and voted. And in 1982, they ended up electing him to be mayor. And the previous mayor and all-white town council, the mayor had always been one of the 3 owners of the big major plantations in the area, was the mayor of the little town. And so the mayor gets ousted, and Eddie Carthan is elected to be mayor. And so the 3 white plantation owners were getting set to run another black guy against him in the 1984 elections coming up, a guy named Roosevelt Granderson. And Roosevelt Granderson, during the school year, was the basketball coach and athletic coach at the all-black high school. And in the summertime, he worked for B.J. Thomas, who was one of the plantation owners that owned the all-white country store. And so the plantation owners were going to run this fellow, Roosevelt Granderson, who worked for them, for mayor against Eddie in the next election. And it turns out that on the Sunday night of the 4th of July weekend of 1983, Roosevelt Granderson is on duty at the Jitney Junior, all this like 7-Eleven place in this little town, and the fire alarm goes off, and because he'd been elected along with Eddie, he got elected to be the only 2 black people on the town council. Bottom line is, he runs off to go answer the fire alarm, comes back, and 2 guys are right behind him, and they push him into the store and murder him and rob the store. And so right away, the white district attorney and the former white mayor all get together and going to blame it on Eddie Carthan, saying that he must have done this to try to get rid of his political challenger. And so that they arrested him and put him in the jail and wouldn't let anybody see him. And so we get brought in to represent him. And so we end up getting ready to pick the jury, right? So this is where this is all coming from. This is having to do with electing the jury or picking the jury, right? So we come into the courtroom, and out from the jury room come out 100 prospective jurors, the first 80 of which are white. And the remaining 20 of them in the back are black. And you have to go through them starting at the front and work your way through these people. And so as soon as they came into the courtroom, I could see them. I thought the judge. I jumped up and I said, "Your Honor," I said, "I'd like to object to this panel." He says, "Yes, Mr. Sheehan. Wait a second. He says, "Look, I don't think we have to have anything in the record here." He says, and I said, "Oh, yes, we do." I said, "I just want to make it clear that when they came into this courtroom, I thought that I was in a snowstorm." I said, I want it on the record that the first 80 of these prospective jurors are all white, and the black people are all at the very end." And he said, okay. He said, here's what we're going to do. He said, we're going to take the 100 names and we're going to put them into a box, and we're going to shake them all up, and we're going to have the clerk of the court draw them out in a new order. And I said, no, we're not. We're not. And he said, well, what do you mean we're not? And I said, no. I said, the clerk of the court are the ones that picked them to begin with. Okay? And I said, what we've got here, I said, we have a representative here at this trial of Amnesty International, because Mayor Carthan is the second American in history to be designated by Amnesty International as a political prisoner. The other one is Leonard Pelletier. Okay? And I said, so that we have a representative from Amnesty International who is here, and what we're going to do is we're going to put all the 100 names into a box, we're going to shake them all up, we're going to have the representative from Amnesty International draw the jury. And the judge said, okay, we'll do that. So they put all the names in, they shake them all up, and the clerk holds up the box like this, and the local guy from Amnesty International from Canada draws out the first all-black jury in the history of Mississippi. 12 straight black jurors came out of that box. Okay, so he would say that he had a jury of his peers, which he wasn't about ready to get. Okay, but once we had an all-black jury, I can tell you the case went a lot more smoothly. And it went even more smoothly when we found out who really did the murder and had him tracked down. And he was hiding actually in a cannery up in Anchorage, Alaska at the time. And our investigators tracked him down and found him, and we got him arrested by the U.S. Marshals because he was wanted on an interstate hijacking charge up in East St. Louis. And so they brought him back from Anchorage, Alaska to East St. Louis via Mississippi. And our friends got the marshals to bring him down into Chula, Mississippi. We brought him into the courtroom and put him up on the stand and broke him right on the stand. And that he confessed to having committed the murder. If we didn't have an all-black jury in that case, we never would have gotten away with that. Okay, so that and this is 1984 that this particular thing happened. The thing with Glenn W. Turner happened in 1973. Now those are, you say, well, gee, that's like ancient history ago, but it's not, because the things that we're going to be talking about in the third part of the course are all happening now. I mean, your grandchildren, if we succeed in dealing with this upcoming crisis, are not going to believe that you were alive at a point in time when the Federal Congress of the United States passed a statute authorizing the United States military to arrest an American citizen here in this country without any probable cause to believe that you've committed any crime at all, simply on the finding of an executive branch official that there is a suspicion that you may have given support of some undefined kind to any person who is associated in some unspecified way with some organization that has in fact engaged in hostilities against the United States or any ally. I can tell you they will not believe it. Okay? So you have the great honor of having been alive while that stuff is still going on. You know? So you get the opportunity to actually participate in getting that stuff stopped. Okay? I mean, it's like being in a movie. You know, I mean, really, you know, you look at, oh, wow, gee, that was the old days when things were really bad, and you could be like Gary Cooper, you know, in High Noon, you know, and you could, you know, save a whole town from bad guys. You know, let me tell you, you have the opportunity to save an entire country from bad guys. Okay, and you're going to get that opportunity here in your lifetime, and you're going to be able to tell your grandchildren about this and what it was like. And that's again, as I mentioned, that's what this class is all about. Okay? So these particular aspects of the due process of law that have been developed down through the centuries here in this country and were embedded in the concept of the due process of law over and against the federal government in that period of time between 1791, when the Bill of Rights was enacted, all the way up to 1868, became the template and the measure by means of which they were to evaluate what it meant when in the 14th Amendment, which we're going to pick up and start discussing on Tuesday, that when that 14th Amendment put into the Constitution the prohibition against any state violating the rights, privileges, or immunities of citizens of the United States, or depriving any person of the equal protection of the laws, or depriving any person of life, liberty, or property without the due process of law, the natural instinct would have been to assume that all of those procedures, all of those aspects of due process of law that had been found to be inherent in any kind of a fair system of justice over and against the federal government would have been automatically enforced against the states under the 14th Amendment, because that's in large part what the Civil War was all about, as to whether or not the federal government was going to have the kind of authority to impose upon the southern states mandates which included the fact that black people are going to be citizens and have the same rights as white citizens, but also the mandate that they were to respect the fundamental rights that every person has in the country, so that there was a systematic consistency throughout the country with what the expectations are that you have about what rights you have. Okay, so that's the issue that we're going to take up on Tuesday, talking about the 14th Amendment and its due process of law. So we're as I say, a little bit behind schedule on what kind of the ideal schedule was that I had in mind for the course, partly because I wanted you to know about what's happening with this case. It's actually called, I guess I should give you the name of the case. The case is the American Civil Liberties Union. The American Civil Liberties Union versus Clapper. And Clapper is the guy that's the head of Director of National Intelligence for the U.S. And it's also against the head of the FBI and the head of the National Security Agency. But it's called the American Civil Liberties Union versus Clapper. And it's in the Second Circuit Court of Appeals, and all you have to do is just Google it, and it'll pop up. Yeah.
I emailed it to everyone, but I made up the name. So.
You made up the name.
But they'll find it.
Okay.
It's similar enough that they'll.
Okay. All right. So you got it. It's been sent to you. So please take a look at that, and I would suggest that what you do, if you have access to it, is get it printed out. I mean, I know that's kind of a kind of a heretical thing to do nowadays. But if you get it printed out, and when you're going through it, just make little notes in the margins. When you get to a spot, mine are filled with bullshit and what crap and who could believe this, and there's a whole bunch of stuff like this. But you can choose your own verbiage, and you can do whatever you want to make little notes so that you can recall where places are in it. Not because we're going to go into great depth about it until the third part of the course, but I just want you to read through it slowly enough so that you've got like a clear step-by-step understanding of what it is that's happening there. And what he's talking, it's a very clear opinion, very clear opinion.
Was there a dissenting opinion published?
No, as far as I know, there's not. And so I can't really tell. I should have been able to figure all this out earlier. There's a concurring opinion. There's a concurring opinion that, I don't know where it starts on here, but it's a peculiar because there's two members of the Second Circuit Court of Appeals, and there's a district court judge that is sitting by designation, which they're doing now because there are vacancies on a lot of the courts of appeals because the Republican Senate now is going to resist appointing judges that Obama wants, and that they've been resisting for all this time. So there's a huge drag and lag on getting appointments to the courts of appeals that Obama wants. I can't imagine that they're still functioning under the fantasy that they're going to win the presidency, but they may be. But at least they've got a hold of the Senate. And so they have the historical example of during the second term of Bill Clinton, that the Republican Senate was able to hold up his appointments to the point where Clinton started appointing Republicans to the bench, and conservative ones at that sometimes. Okay, so I want you to read this, and whereas I had hoped that we were going to be able to be started at the beginning of next week on part 3 of the course, we're going to be a week behind because we're going to have to. We want to cover the 14th Amendment, the due process of law, equal protection provisions of the 14th Amendment, and the 9th Amendment as well. Okay, so we'll do that during next week, and then we'll move on to the. Now, people want us to start thinking about potential focus for your final paper, but let's refresh your recollection first about your second essay. The second essay, which will be due, what is it? Next Tuesday, the Tuesday after this one coming. Okay, it's the 19th. The essay will be I want you to pick out one of these enumerated rights or designated rights that we're going to be talking about here in these past 2 weeks. First Amendment, a free speech, or any of the rights that are part of that constellation, freedom of expression, freedom of the press, etc. Any of the Fourth Amendment aspects of the rights to privacy. The issue of the Fifth Amendment rights to due process, or the equal protection of the laws that we're going to be covering next week. Pick out any one of those particular issue areas, and I want you to tell me, what it is that you think about that particular right. Show to me that you understand what the implications of that right really are. Articulate for me what the best challenge is. Not just some straw man, some complete crap argument that the reactionaries make against it, but what do you think the real problem areas are? Now, you remember when we were talking over in the section, we're going over there now, but remember we were talking in the section at the end of it last Thursday, we hit upon a belief that there should be some kind of law that prohibits somebody outside of the dorm rooms kind of exposing himself and scaring people and stuff like that, that there is another end to this, a limit to this free expression thing. And that if you can understand what the principle is, that is a challenge to the exercise of this right that you picked. Articulate what it is, and then I want you to articulate what the most effective counter argument on behalf of the expansion of the right is. All right, so that you'll get that exercise. And you remember now, I've in preparation for the due process of law discussions next week, I've given you a list of these cases that I want you to take a look at. And there's a list of them from Griswold versus Connecticut, which was the United States Supreme Court case that established the right of married couples to be able to use birth control. I've also assigned Eisenstadt versus Baird, which is the case that I did that expanded that right to be able to be available for unmarried people. Skinner versus Oklahoma, which is a case where there was a state statute that sterilized people as a punishment for crime. Then there's in Pierce versus the Society of Sisters. There's a whole set of them, but every single one of those that you read, you're going to be fascinated by the case, because it's become kind of a paradigmatic case dealing with some of these fundamental rights. Okay, so let's get on over to our section meeting. There's a lot to talk about this week.